Our participants, Zoom and in person. I'll just remind everybody, try to use the names, not the names, but the initials, please, as we are broadcasting this afternoon. So that being said, I'm looking forward to a hearing on the prelim in this case, and the request for jurisdiction over the children. May I have the names of our participants, please?
Good afternoon, Your Honor. Nicole Underwood, legal guardian ad litem for the minor children.
Good afternoon, Your Honor. Clay Tipton, appearing on behalf of the department.
I'll try with the department.
Michael McFarland, representing Mother. Please introduce yourself.
Robin Hardy.
Did the court hear that?
I did not.
Robin Hardy.
All right, would you spell that for us, please?
R-O-B-Y-N.
Henry Dumont for father, Tyler Long.
I'm Tyler Long.
L-O-N-G?
Yes.
Got it. Okay, thank you. All right. I know we were on record one other time and we made the decision to adjourn this to allow the attorneys to talk with their clients. Have you had a chance to do that, Mr. McFarland?
I did, Your Honor. If the court finds there's sufficient today to proceed, we are requesting a bench trial.
Okay, that's good.
But we are prepared for today.
Very good. Have you had a chance to talk with your client, Ms. Dumont?
Yes, Your Honor, and we would be requesting the same thing.
All right, 2 bench trials requests. Good. Well, I can set about scheduling that, and in the meantime, let's go over some of the preliminaries for our prelim hearing. Deputy Ames, would you swear in Mr. Tyler Long and Ms. Robin Hardy, please?
You can remain seated, but please raise your right hands. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God? Can you say that out loud, please?
Yes.
Thank you. Thank you.
Okay, thank you. So I just have some questions for both of you, many of which you may have already had to answer in the process of looking through the petition, but I'm going to go over that with you one more time. Do each of you have a copy of the physical petition? Ms. Hardy, do you have a copy? It's
What we went over at my office.
Yes.
okay. Mr. Long, do you have a copy?
Yes.
Very good. All right. Are there any other cases? It looks like there's a DC case for the older child. Are there any other cases that you're aware of, like a guardianship, child support case, or anything else that could concern either of your children? Ms. Hardy?
Not that I know of. I don't even know what that first thing is.
Okay, well then that probably doesn't apply. Mr. Long, any other cases that you're aware of?
No. Your Honor, I will say one thing that we did not see that it was said it was attached with the petition is the safety plan.
All
It was
right.
not in my petition. I didn't see that in my client file.
Which allegation?
I will go back and read that.
Okay. All right, I'll let you look at that then as I go through these things. So both of you have the right to an attorney for purposes of this and all proceedings. If you want to retain your own attorney, that's fine. That person would have to contact the attorney that's been assigned to you to get the information they need moving forward. But Mr. McFarland and Ms. Dumont will be here to assist you until and unless that decision is made. You have the right to ask for placement of your children. And at this time, it does not look like the department is asking for the children to be removed from your care. We're just asking the court take jurisdiction and direct to avoid some of the things that they are noticing that they think are risks in the household. You have the right to have the petition read to you on the record, including all of its subparagraphs, which looks like it's a total of 4 pages. Mr. McFarland, have you talked with your client about that?
Yes, I have read that word by word. She does have some learning difficulties, so I went in more simple terms also with her. And in answer to your earlier question, it was number 8, which references C attached. Number 8 is the safety plan.
Thank you. Do you know if your client would like me to read the allegations or if she would like to waive that?
No, we would waive that, but we just haven't seen, I've not reviewed with her the safety plan.
Thank you. Duly noted. I'll let the workers worry about that and maybe we can remedy that by email.
Yes.
Thank you. Okay, Ms. Dumont, have you talked with your client about his right to have the petition read and would he like to exercise it or waive it?
Your Honor, we would waive that. We have went over the petition together.
Thank you. Very good. All right. Do either of you have any Native American heritage or have any reason to believe that anyone in your family could qualify for that or that your children may be eligible for membership in any Native American tribe or band? Ms. Hardy.
A little.
I've discussed that with my client in the presence of her father, and he believes there is Native American heritage on his side of the family.
All right, it does look like there is a BIA request that's already been sent out on that point. Do you, have you asked your client if she's provided all possible information about that already?
Yes, I'm not sure if anybody has spoken to her family, her father, or anybody else on that side. But I think she knows she's disclosed.
Okay. All right, just put a pin in that and we'll follow up with you in a minute on that. All right, how about your client, Ms. Dumont? Have you talked to them about that?
Yes, Your Honor, he indicated his mother, right, might have a little bit, but he doesn't believe it's enough to warrant an investigation.
Would you be interested in supplying that information just in case?
Yes, Your Honor. Your Honor, he doesn't know what tribe or how much it would be,
Okay,
so.
thank you for asking. All right. Each of you have the right to trial by judge or by jury, wherein the court would have to determine whether or not there's probable cause to move forward on the petition. And obviously your attorneys have talked with you about that. You wish to request a bench trial, which is great. I'll schedule that. You would also have the opportunity to admit or deny the allegations and make a statement of explanation. Do you have an official position on that, Mr. McFarland?
Yes, Your Honor, if I stated on the record, if it does proceed to trial, we wish to have a bench trial.
Thank you. Same question, Ms. Dumont.
Yes, Your Honor, we would agree we would want a bench trial.
Guess my only concern would be, we want to hear back from any possible tribes or Department of Indian Affairs prior to proceeding.
Well, we'll hear an update on that very soon, I'm sure. I do have documentation that was supplied with the petition, and I'm hoping you all do as well, that request to the BIA went out on 9/16/2024. So we're looking for an update on that. Looks like legal parentage has been established for your client, Ms. Dumont, by way of an affidavit of parentage for both children. Any reason we would need to be concerned about those determinations?
No, Your Honor.
All right. All right, so for purposes of today, we're just looking to determine whether or not there's probable cause that one or more of the allegations of petition are true and fall within the statute for purposes of moving forward on the petition itself. Rules of evidence do not apply, and that's pursuant to MCR 3.965 subsection 12. At this time, Mr. Tipton, how would you like to proceed?
Okay, Your Honor, I guess I maybe have been confused. Are you asking Ms. Dumont's client if he's the father of all the children?
I only have 2 children named in the petition, and I have 2 AOPs.
My client indicates that she does not believe he is the biological father of one of the children. I can have her placed on the record. There's another possible father out there. I just found that.
Well, we do have an affidavit of parentage for both children, so
Okay,
he has been determined to be the legal father. I'm not really, I wouldn't be obligated to move, or the department would be able to move if I ordered them on a DNA testing, but is that something?
well, I guess, Your Honor, let me talk to my client. I mean, if that's something she discovered after the fact, I don't want her to commit fraud in filing a document like that, but if we possibly have another father out there that has legal rights, well, I can just confer with her. I just discovered this. If I can take her up in the hall just a moment.
Well, any such person would have to file an action to set aside that parentage under the Revocation of Paternity Act.
Well, I know this court has also done that. Testimony determines that there was some type of fraud or concealment, intentional or accidental on that matter. So I've not explored that, but I've just been told that there may be another potential father out there.
What is the name of this person?
Yeah.
And is it for the older child
Judge,
or
court
the
just
younger
needs to know his
child?
name.
He doesn't want to be known as
Judge
the
is asking,
father.
judge is asking.
He doesn't want to be known as the father.
Is this for the older child or the younger
Yeah, the
child?
older child.
Okay. So are you asking us to investigate that or not?
No, he's the dad.
Who's he?
Tyler, legally and everything since birth.
Yes, I'm aware of that. I have legal documentation to that effect. Is there a reason to believe that we should investigate that any further?
No,
Okay,
I would like to confer with Ms. Dumont for just a moment, Your Honor.
sorry.
well, why don't we leave that? We have a legal father. Why don't we leave that until the end of today's proceedings? And then you can let me know how you want to move on that at the next pretrial. My intention is to schedule a pretrial and a trial.
Fair enough.
Thank you. All right, so for purposes of today, Mr. McFarland, well, let's stay with you. Your client does certainly have the option to waive the probable cause finding and to allow the petition to move forward. Or we can ask Mr. Tipton to present any evidence that he may want to in order to allow this to move forward. What
We wish to have a presentation of evidence.
I'm sorry?
We wish to have a presentation of evidence.
All right, Ms. Dumont, does your client wish to waive the probable cause finding, or would he too like to hear what the department has to say?
We would like to hear what the department has to say, please.
Okay, Mr. Tipton, back to you.
Just had a trial to the standard, and also the supervisor of the department as well was booted out of Zoom as a consequence of.
Oh, yes, I do see her in the waiting room, so she's back in. All right, come on up to our witness stand, Ms. Hannah Trout.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, proceed it will.
Are you the Family Services Investigator for the Department of Health and Human Services?
I am.
Are you also the petitioner in this matter?
I am.
And you're the petitioner regarding the children AL and RL?
I am.
And how old is AL?
I'm sorry, I don't know off the top of my head.
5 years old, is that?
Yes, that sounds right.
Okay. And RL is an infant?
Yes, he's only a couple months old.
Okay, and how did you become involved with this case?
We received allegations when the infant was first born that his meconium was positive for THC.
Okay, and at the time, was there a safety plan developed?
Yes, there was.
What was that safety plan?
There was a marijuana safety plan developed in regards to not using in the presence of the children, not using when you're alone with the children, that there would be a sober caretaker in the home, having the substances locked up, and then not driving if you're going to use.
Your Honor, I'm objecting, and the reason is, as I stated, we don't have a copy of that safety plan that was attached. I thought we could be provided with that.
Well, is there an evidentiary aspect to your objection? She's just testifying to what her recollection is of that safety plan. You're welcome to cross-examine and to continue making that request in the future, but if there's something more specific that I could look at under the rules of evidence, I'd be happy to look at
Well, it's
that.
hard for me to cross-examine him. I don't have the document that was supposed to be supplied in the petition itself.
Yes, Mr. McFarland, is there a specific objection under the court rules you'd like me to entertain?
No, not, well, not at this point, Your Honor. I will withdraw that. I'll come to that.
Very good. I remain at your disposal should you decide otherwise, and I think there was, do you want to speak to that quickly?
It was supposed to be attached with the petition. I apologize that that did not get circulated. I did make sure that our attorney, I emailed it to him just now when you guys were talking, so he should be distributing that probably shortly after the hearing.
Does that help, Mr. McFarland?
Yes, Your Honor.
Very good. All right, sorry, you may continue.
No problem, and I appreciate my client falling on the sword, but it may have been my error in not attaching it to the petition, so we'll get it to counsel immediately.
Thank you.
And did you have an opportunity to speak with the mother of the children?
I did.
And who was that?
Robin.
And who was the father of the children?
Tyler.
Okay, he's the legal father of both children.
Yes, yes.
Okay, and did you have an opportunity to speak with her about why she was testing positive for marijuana?
I did.
And what was her response?
She claimed because of medically, she was in a car accident and has a lot of pain from that. So she uses marijuana to cope with the pain.
And was there a conversation of how whether or not she was nursing the youngest child?
Yes,
RL?
yes, she said that she is breastfeeding.
And Robin agreed to take any drug screens at the time during your investigation.
She did.
That investigation occurred, was it in August of this year?
It was August to September.
Okay. And what were the results of the drug screen?
So there was multiple drug screens. We conducted two. The first one, she tested positive for her Suboxone, which she does have a prescription for, and THC. The second drug screen, she tested positive for THC and alcohol.
Was that within that time frame of August of this year and September?
Yes, both of those were.
Could you repeat that? Sorry.
What was that?
Could you repeat that last statement? She tested positive for what?
Her first drug screen or her second one, you need?
Both.
Okay, her first one, she tested positive for her Suboxone and THC. The second one was alcohol and THC.
And this was recently?
Yes.
Was that the only time you had contact with?
I did
Really?
request to do a third drug screen with her, which she did not wish to complete. She said that she would go to Lenawee Development Corp the next day, which she did not do.
And was there any other time that you became involved with this case or had contact with Robin?
I don't know the exact number of times. I showed up a few times for unannounced visits and attempted phone calls with her. I can't say the exact number of time that I had contact with her.
Okay. And had Robin taken RL to his well baby visits?
Sporadically, there was multiple canceled appointments or no-showed appointments. He did go to a couple of them that were rescheduled, but they've been very sporadic since he was born.
Was there any important point in time that you as an investigator became involved or became concerned about one or more of the child well visits?
Yes, I called to follow up on one of his well child visits, and I was made aware that she showed up to the appointment appearing under the influence of substances. They said her words were very slurred. She was slow to respond. They could not say the exact substance, but they believed it was alcohol. She said that her mother drove her to that said appointment, but the hospital did not see the mother. Robin claimed that her mom was waiting in the car.
Okay, and as part of your duties as a protective services investigator, did you try to contact Robin?
I did. That is when I went out to the home a few hours later, and that is when I asked her to drug screen the second time. And that's the one where she showed up positive for alcohol.
Did she make any statements to you regarding that positive drug screen?
Once I received the results back, she claims that she did not drink any alcohol. She and Tyler believed it was something that she ate that would have showed up positive for alcohol. But they both told me that neither of them cook with any alcohol or anything along those lines.
And after that positive drug screen for alcohol, have you made any attempts to try to contact Robin again?
Yes, me and the ongoing worker has tried to make multiple attempts with very few that were successful.
Were there any family team meetings requested?
I
or
did.
conducted?
I did attempt to schedule a couple family team meetings. I ended up having to show unannounced and complete one. I showed up unannounced to the home, but Tyler was not home. So I went out later that afternoon when I knew he would be home, and we completed kind of like an impromptu family team meeting, which is when we were discussing the alcohol results where they were denying everything.
Was there a safety plan requested by you or anyone in your?
We reiterated the same marijuana safety plan that was previously agreed upon. When I discussed doing an alcohol safety plan, they did not wish to complete one because they were denying any alcohol use.
Now, the Lenawee Development Corporation, what is that exactly?
They are a service that we use here in Lenawee County for drug screens, which I believe at the end of the month, we're not allowed to use them anymore. But they used to do drug screens for us.
And after, were either of the parents cooperative with you regarding communication or?
Very minimally. We've been able to make contact very few times. That the ongoing worker has been touching base with the family since I filed the petition. So I don't know the exact amount of contact that she has had with them.
And who's the ongoing worker?
Megan McVeigh.
And during your investigation, you had opportunity to speak with Tyler?
Yes, I did.
Okay, was he cooperative with the safety plan or communication with you at all?
I was not able to make any phone communication with him. I called and texted him on multiple occasions, which I did not receive a response. He says he works a lot, which is why I never got a response. He assumed that Robin was handling everything. I was able to make face-to-face contact with him a couple times, where they would not, that is when we tried to do the alcohol safety plan, and neither of them would do that. And then I completed the marijuana safety plan with just Robin because I had no concerns of him using marijuana.
Did he make any statements to you regarding Robin using marijuana and nursing?
He was aware that she was using marijuana. He did not know the frequency. He just says he knew that she was using.
And did he know that Robin was nursing?
He did.
Okay. Does either of the parents have any CPS history?
Yes, they do. Not a whole lot. There was an investigation when the oldest child was born, and I believe one more after that, but I don't remember the exact details. I do know there was one substantiated case.
And does either of the parents have any criminal history?
I believe Tyler does, but I don't remember the exact. I believe he reported that he was on probation before and did have to drug screen for probation.
And what are you requesting regarding this petition?
At this time, we were just requesting for in-home jurisdiction and cooperation from the parents to participate in services.
Thank you. I have nothing further to add.
Very good. It looks in the petition, there's 3 CPS cases filed against Robin Hardy. 2019, 2020, and 2021. Do you know which, if any of these, were substantiated cases?
I believe I should have it marked in there. There should have been a category 3,
Okay.
which would have been substantiated.
One says opened, closed, and the other says nothing.
So
There's
okay, so then they were both substantiated. The open closed one would have been substantiated, and then no, we would not have had a ongoing worker with them. The just plain category 3 would have had an ongoing worker check in on them and refer services.
Thank you for that clarification. Mr. McFarland, cross-examination?
Yes, are you sure my client didn't advise you that she was attempting to breastfeed the child?
I do not remember her saying attempting. I know that she said that she was going to breastfeed. The word attempting, I don't recall.
So going to breastfeed means that's a future that she wasn't currently breastfeeding, but she intended to down the road. Am I hearing you correctly?
When there are infants and mothers report that they are going to breastfeed, they're breastfeeding. There was no formula in the home or anything, so I was assuming.
Go ahead.
Under assumptions that she was currently breastfeeding.
Oh, but she told you she was going to. Did I hear you correct?
I don't remember the exact wording that she said.
What do your notes reflect, please?
I don't have my notes on me. I have the written petition, but I don't have my notes.
So you tested the infant to make sure that the infant wasn't having marijuana in its system and was at risk, correct?
The infant tested positive, his meconium tested positive for THC.
That was a newborn, correct?
Correct.
That was not the infant
We don't continue to test infants.
So you didn't have any concern that the infant was ingesting marijuana through mother's milk?
We can't test them, so
You
I
can
don't,
ask, right?
I don't believe so, unless hospitals do that. But that is not something that we can do. And we can't do like a saliva screen or anything on an infant.
Do you happen to know what's the concern with what level of marijuana in a child's system poses a risk of harm to the child that mom is using? Do you know?
I don't, I'm not a medical professional, so I don't know those answers or levels.
So really, you don't have any evidence that the child had marijuana in his system. Is that correct?
Correct.
Thank you. You have no evidence that the child had any alcohol in its system either from mother's breast milk, correct?
Correct. Again, we can't screen infants, so I would have no way of getting evidence for that.
Who you asked that you can't screen an infant for either?
Per DHS policy, we cannot screen anyone under the age of 18, which includes infants.
Even with consent of a parent?
Correct.
You happen to know that site so we can look it up?
You probably could just look up Michigan CPS policy. I don't have a number or anything else.
That's what I was asking. Do you happen to know?
I have a link on my computer of all of our policy. If you would like I could try to find the exact.
That's fine. I'm just asking if you know.
Okay.
What was mom's exact blood alcohol content when you said that she tested positive for alcohol?
Forensic fluids cannot give us an exact number.
That's all I need to know. Thank you. You then went to mom's place, if I understand, residence, and asked her to screen for alcohol prior to her screening, right?
Correct.
Did you smell alcohol? I don't see in your report or in your petition that you smelled alcohol in her breath. That's not in the petition, correct?
Correct.
I don't see in your report that she had eyes that were watered over. I don't see that in your petition, correct?
There were concerns of her demeanor.
That's not what I asked. I'm asking in your petition. I don't see any language where you observed her to be under the influence, correct?
I believe I did put my observations in my petition.
Yeah.
It's at my desk, though. I don't have the.
Well, if we could provide that to you, and you tell us what number you're alleging that your direct observations?
That's what I'm saying. I don't have it. I can't tell you a number. I would have to flip through it and find what number it was.
It's number 13.
Fair
Sorry.
How far away were you from her when she was talking?
Maybe about 3 to 5 feet.
Don't you think that you'd be able to smell alcohol if you thought her conditions were from alcohol?
Jackson, you call it speculation.
Well, let me rephrase that. I'll withdraw that. You've had some training as far as people consuming alcohol, I would presume, is in your job, right?
Yes.
One of those would be the presence of an alcohol odor, right?
Correct.
What did mom tell you as to why she was why she had maybe slurred speech or couldn't keep her eyes open? Well, let me ask you, didn't she tell you that she was deprived of sleep is why?
Yes, she said she was tired.
Mom, when you did get the test results back from some unknown quantity of alcohol, did you tell mom that she had the right to have that sample tested at her own expense? Did you tell her that?
So we sent out the samples, so I can't retrieve the sample back. But I told her that she could go to Lenawee Development Corp and do her own drug screen at her own expense.
How many days after she gave the test, submitted to the test, did you get the results back? About 5 days?
I believe it was about 5 to 7 days. It can take about a week or so to get the results back due to the quantity of the screens we sent out.
You know, the samples still exist?
I don't.
No further questions.
Did you have some questions, Ms. Underwood?
Oh, I do have one, if you don't mind, Your Honor.
Go ahead.
Didn't my client tell you, as far as the sores with blood dripping down her face, that she was recovering from poison ivy? Didn't you recall that?
She did not tell me that.
Fair enough.
Okay, questions, Ms. Underwood?
Yes. Good afternoon, Ms. Trout. Can you hear me okay?
Yes, I can.
Okay. As far as the blood alcohol screenings that are done by forensic fluids, isn't it true that it'll only show a positive test for alcohol if the person tests above the legal limit?
That is true.
Okay. So a person's BAC.
I object in that she's not an employee there. I guess, how did she have that knowledge, Your Honor? So it'd be.
Can I speak on that?
Well,
It's in the
technically,
petition.
It's in the petition, 15. The information came from forensic fluids, is that right?
Correct. I called them.
I just wanted that testimony, Your Honor. Thank you.
Your next question.
Mr. McFarland asked if you had any evidence to support that the child tested positive for marijuana, and you indicated no. However, in your petition, it indicates that the child did test positive when he was born. Is that correct?
Yes, his meconium was positive for THC.
Okay, so that is evidence supporting that the child has tested positive. Is that fair to say?
Yes, that's correct.
Okay. Since the petition's been filed, and this hearing has been adjourned, is it you that has continued to make attempts to be in contact with Robin and Tyler?
No, that would be the ongoing worker.
Okay. Do you remember how many approximately well visits the youngest child missed?
I believe it would be between 3 to 4 well visits that were canceled or no-showed.
Before the case was transferred to ongoing, was there any additional attempts to drug screen either party?
So outside of the 2 where I received results, there was one other attempt after that where she denied a drug screen.
Okay. If the court were to authorize this petition, what type of services would the department be offering this family?
So we have a couple services. We have safe care, excuse me, that this family was actually chosen for. They can't be referred, they have to be chosen. They were chosen for safe care. We also have a new program called My Family Together that could possibly be referred. There's also substance abuse counseling or general counseling if needed. But that would be something that Megan would work on referring for services.
Okay. Are you aware that there is also a pending retail fraud case against Robin at this time?
If I recall, I remember seeing it on her criminal record, but I did not recall exact details about it.
I have no further questions. Thank you.
Have you received anything back from your Bureau of Indian Affairs inquiry?
We have not, and I actually had someone check just a couple minutes ago and there's no updates for it.
All right, would you be able to supply a copy of what was sent to the BIA?
Yes, I can.
Thank you. Redirect,
No redirect, Jack. Thank you.
recross?
Just 2 questions.
Oh, you know what? I forgot Ms. Dumont because I can't see her behind the.
Oh, I'm sorry, you're right, you're right.
I'm sorry.
Ask about that.
I'm really sorry.
Oh, you're fine.
Do you have any questions?
Just a few. Ms. Trout, you testified there is no indication that Mr. Long is using any marijuana, alcohol, anything like that.
Correct,
And so that's why you don't drug screen him.
correct.
Okay. And he advised you he has a pretty heavy workload and that's why he's not always available to be spoken with.
Yes,
Okay. Okay, and you placed in your petition that he has no CPS history.
yes, correct. None on him directly.
Okay. Okay. And I mean, with regards to the petition, there wasn't really anything and specifically involving any concerns with him and the children, correct?
There was just more concerns of him minimizing the concerns with Robin, the concerns of her usage and him knowing and not properly safety planning around, and then the concerns of the alcohol and him denying everything.
So he believes, and he had told you that she isn't consuming alcohol.
Correct.
And that possibly could be true depending on, you know, the information that he has.
Yes.
Okay.
Okay, Mr. McFarland.
Now that you've heard father may have Native American heritage, presuming you're going to now do an inquiry as far as ICWA for him?
I can send an additional one, but the original, we do include both parents no matter what. If he has additional family names and stuff, I can send out another one. Originally, it was just his name. I didn't have any family members. But his name is put on the original inquiry no matter what.
What's your concern for the child, that meconium was in the child? That in the meconium there was tested positive for THC. What's your concern with that?
So I'm no medical professional, so I cannot speak exactly of the concerns, but I do know when I spoke to the pediatrician, testing positive for THC and continued exposure can cause issues with the child developing and everything. But again, I'm no medical professional, so I don't want to speak directly on what the concerns could be.
There were no medical records from the birth of the child indicating any harm from my client if she did consume THC. You'll agree with that, correct?
Correct.
Well, even if there was THC, the child was not in any way affected by that based upon the medical records, correct?
I didn't receive everything from the medical records, so I don't know, maybe they did note something, but that would be a question better suited for maybe a lactation specialist that she has talked to or the doctor themselves of their concerns and how it could affect the child.
She's told you her lactation specialist says there's no studies indicating pro or con on that, correct?
She has told me that, but I
Thank
spoke
you.
to the lactation specialist and they told me otherwise.
Well, I don't see that in your petition, correct?
That was after the fact.
Okay. I have nothing further.
All right, now last chance for any redirect.
What did the lactation specialist tell you about?
She told me that she did express the concerns to Robin of marijuana usage while continuing to breastfeed. There are signs posted all over the office expressing concerns and the risks associated with it.
But she did express that to Robin, that's her testimony.
Yes, she did.
Thank you. That's perfect.
Do you have any other questions, Ms. Underwood?
No, Your Honor, thank you.
Ms. Dumont?
No, Your Honor, thank you.
Okay, Mr. McFarland, you've already had 2 shots, but anyone?
Nope, I'm satisfied.
All right, thank you for your testimony. We return to your seat. Anyone else you'd like us to hear from, Mr. Tipton?
Yes, is Ms. McVeigh still with us?
Ms. Megan McVeigh, do we still have you with us?
Yes, I'm here.
Good. Thank you.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Can you hear me okay, Ms. McVeigh?
Yes, I can.
Okay. And you're the ongoing specialist for the children?
Yes.
Okay. And how often do you meet with the family?
I meet with them monthly and service providers will meet with them more frequently.
Are there any services that you're providing to this family?
The one service that they did agree to participate in is the safe care services. That would be a weekly home visit.
Okay. And safe care, what exactly is that?
It's a parenting program where they have different modules for the different types of parenting. Usually they come to the home to work with individuals.
Let's see. Did you have opportunity to speak with Robin about perhaps a safety plan regarding refraining from marijuana or alcohol use while?
Yes, we discussed it at the home visit that I conducted.
And what was her response to you?
Said that she was not using any substances.
Okay. And did she agree to participate with any drug screens at all?
She did go to LDC.
Okay. And when was that call?
Excuse me?
Do you recall when that was?
The date? I can get it in just a second if you need the date.
Sure.
Just a second. The drug screen was on 10/11/24.
You got the results of that screen?
Yes, I do.
What are the results?
She was positive for THC and Suboxone.
Okay. Is there anything else in regards to a safety plan that you went over with the family?
I did discuss with Miss Hardy about if she was going to continue to use substances to not be breastfeeding her child. And she was observed to be giving the child breast milk when I was present, and she said she had not been using.
I see. Have they been cooperative with you in regards to following any type of safety plan or any type of suggestions?
They did cooperate with a home visit, and they said that they would participate in safe care services. But as far as the safety plans go, especially after getting this drug screen result, it doesn't look like she's following the not using part of the safety plan.
Was Tyler present when this was discussed?
No.
Okay. There was opportunity to speak with Tyler regarding any safety plan?
No.
Okay. Thank you. I have nothing further now.
Mr. McFarland?
There's a possibility that if my client stopped when asked, that if she had been a heavy user, that it would still be in her system based upon your last test, right?
I don't know how long ago her last test was.
How long does it remain in her system with your testing?
I don't know because this is an LDC drug test and we don't typically use these. I would have to call the company and ask them.
So you don't know if the positive test result was because of active use or residual from prior use, correct?
I don't know that.
Fair enough. Nothing further.
Ms. Dumont?
Ms. McVeigh, were you only unable to speak with Mr. Long because he was at work?
Yes.
And you don't have any concerns with his parenting at this point, is that correct?
Yes.
Nothing further.
Ms. Underwood?
Miss McVeigh, was the youngest child recently seen at the pediatrician for a cough or a cold?
Yes.
Okay. And did the parents fail to take the child to the follow-up visit?
There was a well child exam that was I believe it was 10/7 that it was supposed to occur. It did not occur. The doctor's office reported it was a no call, no show, but it's rescheduled for 10/22.
Okay. Since you have become the ongoing worker in this case, what would you say that mom's level of cooperation has been?
She's been responsive since I've been working with her. She's answered text messages, she's answered phone calls, she participated in a home visit, and she participated in a drug screen.
And what has dad's level of cooperation been at this point?
I haven't been able to contact him yet.
Have you made attempts and he has not reached back out, or have you not attempted?
I
Just
have
to
not
clarify.
attempted.
Okay, and how long have you been assigned to this case?
About 2 weeks or 3 weeks.
Okay. Thank you for your clarifications. No further questions.
Any redirect?
Redirect, thank you.
Any recross?
Just one. Why was there no attempt to contact father for 2 weeks?
I haven't contacted him for 2 weeks. He was just seen. In my case, we're required to see the parents monthly in the home, and he's already been seen in the home once monthly.
Thank you. Okay. Now I understand. Nothing further.
No questions, Your Honor.
Okay, any recross, Ms. Underwood?
No, Your Honor.
Okay, anything else you'd like us to hear from Mr. Trevor or Mr. Tipton?
No, Your Honor, Department rest.
Okay. Testimony today, Mr. McFarland.
No, Your Honor, the burden's on the agency.
Thank you. Ms. Dumont?
No, Your Honor. Thank you.
Ms. Underwood? Any witnesses?
No, Your Honor.
Very good. All right, comments in closing, Mr. Tipton?
Yes, thank you, Your Honor. I ask the court to find that as probable cause, and make a finding that probable cause exists that one or more allegations in the petition is true. The testimony from Ms. Trout was very thorough. We have indications of obviously drug and or alcohol use by the mother while she's nursing the child, RL. We have concerns about her appearance during one child well visit with slurred speech, failure to keep her eyes open. It was the same type of behavior when my client visited her. It prompted her to do a drug screen, which was positive for marijuana and alcohol. And according to the petition, according to forensic fluids, that someone would not test positive for alcohol if it was above the legal limit. In regards to the father, I think we have some minimizing of the situation of the drug and alcohol use while the mother is nursing his child. And even though, you know, he works a lot and I can appreciate that, it was a little bit of a failure to protect because there was, the concerns that the agency brought up to him or simply purchase some formula for the child until we have a situation where the mom is no longer using marijuana or at least testing negative for marijuana. And if she's not, if she still maintains that she's not using marijuana, we have a test here which she can take today to convince the court that she's no longer using. I think that there's been enough evidence to be presented, Your Honor, that the court can find probable cause and authorize this petition to be filed.
Mr. McFarland?
Well, Your Honor, taking a look, so we have marijuana in the meconium of the child. We have to link that to a risk of harm. There are no records that if my client was using marijuana during the pregnancy, that caused any harm to the child. So that's not a risk. Any ongoing issues? Well, we don't even know what level, based on the testimony of the worker, if my client was using marijuana, that would cause her not to have capacity or would impair her. We don't have that. I don't see that in the drug test results here. We need something more positive than she was using. So what if she was using? You need some tie that there's a risk of harm to her parenting ability, her capacity. We don't have that here, Your Honor. Once again, same with the alcohol. Tested positive for alcohol. Now, we have them saying that it had to be this level, but we don't have any definitive results that it was 0.07, 0.04, 0.09. We don't know. It's not here, Your Honor. And my client was not offered a test to have that same sample retested. And if it comes, the results come days afterwards, what good does that do her? What level, if my client is currently using marijuana, does it take for there to be a risk of harm to the child? Once again, we don't have that in here. There's no testimony to that. You can shout wolf, you can say there's a fire, but we don't have any concrete numbers in this petition that would say her behavior is of risk of harm. We don't have any testimony today, nothing in the petition, but there was not another adult that would be able to watch the child. As a matter of fact, we have the contrary. We have the worker testifying that there was evidence, testimony that my client's mother was present. So even if she was using, we don't know that she was in charge of the child, that there wasn't another responsible adult. We don't know that. It's not in the petition. It's not in the testimony. I think this is such a weak case, Your Honor, that they have not met their burden of proof. We ask that this case be dismissed.
Comments, Ms. Dumont?
Yes, Your Honor. From our perspective, there's no instances on Mr. Long's behalf of neglect. He works to support his family. That he has no marijuana usage or alcohol consumption, and the department isn't concerned with him doing that, so much so that they don't drug screen him or contact him. There was also testimony that there wasn't any issues with his parenting skills at this point. So with regards to Mr. Long, we would ask the court to find that no probable cause exists and deny authorizing the petition on his part.
Ms. Underwood?
Your Honor, I think that the key word that I keep hearing here is minimizing. It seems like the parents are minimizing potential issues that the department has been finding. The attorneys are minimizing the potential harm that these children, especially the youngest child, face. Any positive test of marijuana in a child is too high. No child should be testing positive for drugs. And the fact that mom has taken enough or used enough for it to pass through to the child is unacceptable. There are two times where Ms. Hardy appeared to be impaired. And again, the drug screens reflect that she did test positive for THC, and one of those, she tested positive for alcohol, which be required, or it would need to be at least 0.08 or above in order for that positive test to even come about. So that is another, I believe, piece of evidence that supports that Ms. Hardy is not making choices that are beneficial to the child. And in fact, there is a substantial risk of harm if she is under the influence of alcohol or marijuana while she's nursing an infant and caring for an infant, for that matter. The fact that there are several well checks and visits that have been no call, no showed, and not attended, that reflects on not only mom, but also dad. I understand that dad works, but he is responsible for this child just as mom is. And if she's unable to make those appointments, then he needs to make sure that that child can make it to those appointments. Also, the fact that dad is minimizing mom's substance use is very concerning. And while I understand he needs to work, there needs to be somebody home to care for that child while he's unable to do so. I believe that that is also a concern and rises to probable cause to support Your Honor authorizing this petition. The lack of cooperation with the department also is the reason why this petition was filed in the first place. The petition does state that there was several attempts made to contact both parties with respect to this case, and there was very little lack of cooperation prior to the petition being filed. So for those reasons, I believe that there is a substantial risk of harm to this child. there's enough, there is probable cause to support authorizing the petition, and I would ask that Your Honor take jurisdiction over these children at this time. Thank you.
Thank you. Well, the court finds all interested parties were given notice for purposes of the preliminary hearing scheduled for today. It was adjourned to make sure that both parents had the opportunity to meet with their attorneys and go over the allegations in the petition. And of course, we had the presentation of the testimony of Ms. Hannah Trout, our investigator in this case today, to assist the court in determining whether or not there's probable cause that there's been a violation of the statute MCL 712(8.2)(b)(1) or 2 or both, that the children's parents, when able to do so, neglected or refused to provide proper care, proper or necessary support, education, medical, surgical, or other care necessary for the health and morals of the children, or is subject to a substantial risk of harm to mental well-being, abandoned or without proper care and custody. 2, ask the court to determine whether there's probable cause that there's been a violation by way of the children's home or environment with the respondent parents by reason of neglect, cruelty, drunkenness, criminality, or depravity, creating an unfit place for these 2 juveniles to live in. I do find that there is probable cause for a violation in this context. We have, even if I were to apply the rules of evidence to this case, we have admissions from mom that she has used THC, that she is breastfeeding. Those admissions were made directly to the investigator. She clearly supplied the information that she has a prescription for amphetamines and THC. So the allegation that there's no harm that can be had from individually these substances was contradicted by some of the testimony that we heard Ms. Trout discover, but also one or more of these substances in and of themselves may pose a risk of harm to her or her child that she's breastfeeding, but together is certainly another thing. There's certainly nothing showing that it's safe to combine things like THC and Suboxone and Adderall and alcohol. I do have pretty definitive evidence that she has been drinking. We have a test that, and Forensic Fluids will have to show this at the trial potentially, but their tests are designed purportedly to allow only a positive showing of alcohol if someone is above a 0.08. And it did indeed demonstrate that Ms. Robin Hardy's blood alcohol level was above that level at the time she tested. She also had THC in her system at that time. So it appears the drug tests are intermittent at best for the things that she is prescribed, and that at worst they're combining with things that aren't something clearly that she's cleared with her doctors to combine, and then she's breastfeeding. So that's definitely presenting a risk of harm to the infant, who was also born positive for THC. I would love to have some additional testimony at trial on the effects of THC on a child. I know in past cases, we've heard at a minimum about that creating developmental delays, creating problems with lactation, with latching for breastfeeding. And I know in older children, there's some studies out there as well. So do we have definitive proof that THC is bad for infants? No. Is it pretty common sense? Yes. Is it also pretty common sense that combining THC, alcohol, amphetamines, and Suboxone is a bad idea? Absolutely. Thank you. So for all those reasons, I do certainly find that there is a violation by a probable cause standard, that this mom is making choices right now that are placing her children at a risk of harm, both because of physically what she's feeding the youngest one, and secondarily because of the state that she's in when she's trying to parent. We have the firsthand observations of Ms. Hannah Trout, that she was unable to keep her eyes open. She's had slurred speech. Apparently, Tyler has admitted that she acts like this, always looks like this, or acts like this. So I have concerns about his ability to understand what a risk it is also to leave his children in the care of someone who is intoxicated to that level, combining intoxicants and then attempting to watch 2 young children, an infant and a 5-year-old. I would note, and this wasn't specifically explored, but it does indicate that there is a potential charge for Mr. Long from 2018 for misdemeanor while operating while intoxicated. And I would certainly hope that he's also not imbibing and using substances when he is home to try to help watch the children. And I'm not reaching that conclusion at this point, but it is concerning that he doesn't think that we need to safety plan around alcohol, even potentially when confronted with the information that the woman who's in charge of watching his children is registering for 0.08 VAC or above. She wouldn't be able to operate a car in that condition legally. And so certainly, I don't know how we can expect to be able to keep up with a 5-year-old or be a healthy person to feed an infant. So there's a lot of issues here, certainly that arise to at least the level of probable cause for the court to take jurisdiction of the family and require them to start taking part in services. But we'll have a bench trial wherein we'll have a better presentation, a clearer presentation of evidence as necessary. And in the meantime, I certainly hope that the family does engage in some services. The one or more of the children is qualified for early on. Those things need to happen. They need to make it to their well child examinations with a sober parent at the wheel and at the helm of parenting. That's what is necessary here. And that's what we're asking you to do. So I hope that you'll take advantage of the opportunity to do some voluntary services. And I'm happy to set our next couple of dates. But yes, I do find probable cause of a violation of both statute subsections 1 and 2 in this case, based on the presentation of evidence today. And I am authorizing the petition for I know jurisdiction moving forward. And let's talk about some dates. Find your trial date first, and then we'll work backwards from there. We're getting into the holiday season, which is never good for purposes of scheduling. Let's see. Sorry. I do have Friday, November 15th. We could start at 10:30, or we could start in the afternoon. If you don't want to use Friday the 15th, I have some options for, I could do a remote hearing the Wednesday before Thanksgiving on the 27th, or a remote hearing on Monday the 2nd or Tuesday the 3rd of December. If anybody has a preference on those dates.
Available 15th in the afternoon.
I have nothing scheduled.
15th in the afternoon.
I'm unavailable, Your Honor, on the 15th in the afternoon. I have a trial before Judge Olsaver.
What are the other dates?
All right. Well, let me put it to the attorneys for the parents. Do you want to consider a remote trial, or would you prefer to be in person?
Well, I prefer in person, Your Honor, therefore my client can talk to me, communicate, shift notes. It's not as easy to do by Zoom, so.
Yes, I do as well. I just want to make sure you have that option. I can give you a backup to a juvenile jury trial Friday, December 13th.
I'm available.
I don't mind. The only issue is I know that the agents will be bringing witnesses, it sounds like, so I'm not stand by it. I'm fine.
Is that in the afternoon here?
I could go as early as 10:30, or I can start in the afternoon, whatever you, I mean, if you think you only need a few hours for it, then we'll start in the afternoon.
We can break for noon as we have a staff Christmas potluck here, which is important.
Right, I don't want to.
Okay, well, I think we can bump it to Monday if you want to do Monday instead.
16th would be perfectly fine by me.
Yeah, sure.
16th is fine. Thank you.
Not sure we'd have Mr. McFarland's full attention after a potluck.
Yeah, I may be in a sleep coma. That'd be a good way of putting it, yes.
Morning or afternoon is fine. with me. It's the 16th.
Okay, I can do 10 o'clock on the 16th.
Fine by me, Your Honor.
Ms. Underwood, is that all right with you?
I would prefer afternoon, but I could make 10 o'clock work if possible, if necessary.
All right, well, I think the main question is how many witnesses are we gonna have? Do we know?
3, my client and her 2 parents, Your Honor.
Approximately 4.
All right, we better start at 10, Ms. Underwood. We
That's
can,
fine. I can make arrangements.
All right, thank you. The other thing is I'll schedule a pretrial and I'll ask everyone to have your witness and exhibit list filed and exchanged by that point. so that we can have a better idea. And when you do your witness list, please give us just a short indication of what each witness would be testifying to, so that all of us can prepare and I can look at the docket to make sure that we have enough time. So we're starting with 10 a.m. on December 16th for the trial. Backing up to look for a pretrial. Mr. Tipton, is there a time where you're already going to be in town you'd like me to consider? I don't know what cases you're on.
I don't think I have any cases with you.
Okay. All right, all right. How about? Well, I could do 1 o'clock Monday, November 25th.
It's fine with me.
I can do that.
That's fine.
Okay, so November 25th at 1 o'clock for our final pretrial. And as I stated, I'll ask you to have your witnesses and exhibit list done by that point. All right, it's only a request for in-home jurisdiction. The court's not been asked to remove the children immediately, but please be aware that obviously you'll have the opportunity to continue working with Child Protective Services. And I think you've got an idea of the concerns that were expressed today, and I hope that you'll take advantage of that between now and when we come back. Unless there's any questions, that's all for today. Thank you.
Thank you.
All right, court's in recess.